Building upon the previous section's discussion of compensation, this final part of the module focuses on a closely related topic: the lawful disclosure of any present or prospective interests a licensee may have in a real estate transaction. Arizona law demands absolute transparency whenever a licensee's personal or financial interest could influence or appear to influence their professional judgment. These rules protect the consumer's right to fair representation, prevent conflicts of interest, and uphold the credibility of the real estate profession. According to ARS Section 32-2153 AA3, it is unlawful for a licensee to engage in any conduct that demonstrates bad faith, dishonesty, untrustworthiness, or incompetency. This includes concealing an ownership interest, an investment interest, or an anticipated benefit from a transaction. The Commissioner's Rule R4-28-1101E expands on this by requiring that a licensee disclose in writing any present or prospective interest they hold in the property or transaction. This disclosure must be made in clear, written form before entering into any contract, purchase offer, or representation agreement, ensuring that all parties have full knowledge before proceeding. For example, if a licensee wishes to purchase a property for themselves, for a family member, or for a business entity they control, they must clearly state in writing to the seller that they are a licensed real estate professional acting as a principal. This must occur before any offer is made. The disclosure ensures that the seller understands the licensee's dual role and can make an informed decision about whether to proceed. Failure to disclose this relationship could be viewed as concealment or misrepresentation and could lead to disciplinary action, including license suspension or revocation. Similarly, if a licensee lists a property in which they have partial ownership, they must include this information in the listing agreement and any promotional material the adjury has disciplined agents for advertising or selling properties they owned without identifying themselves as the owner agent. Transparency prevents even the perception of self-dealing, which is a core violation under R4-28-1101E. Disclosure obligations also extend to prospective interests, meaning situations where a licensee anticipates acquiring an ownership or financial stake as a result of the transaction. For instance, if a salesperson helps a developer locate land and knows they will later receive a share of profits or partnership interest in that project, this must be disclosed to the seller or any buyer before negotiations begin. In Hoffman v. Greenberg, 1972, the Arizona Supreme Court ruled that a fiduciary's failure to disclose an anticipated interest, even one not yet finalized, constitutes constructive fraud because it deprives the client of material knowledge that could affect their decision-making. In any case, Hoffman should have had his own appraisal done and not relied on someone else's appraisal report. The appraiser also did the appraisal for only John Olson, who hired Greenberg, Campbell, and Associates in the first place. In practice, this requirement often applies to situations such as wholesaling or equitable interest transactions. For example, if a buyer under contract intends to assign their purchase rights to another party for profit, that buyer or their agent must disclose this intent to all parties. A licensee assisting in such a transaction must ensure the disclosure is in writing and signed by the seller, confirming their understanding that the buyer's interest is assignable and potentially being sold for gain. The disclosure of financial conflicts also extends to referral relationships and affiliated business arrangements. If a licensee or their brokerage owns an interest in a title company, home warranty firm, or mortgage lender, that relationship must be disclosed in writing to clients before or at the time of referral. Under RESP Section 8C4, an affiliated business arrangement FBA disclosure statement must be used, detailing the nature of the relationship and clarifying that the client is free to choose any provider. For example, if a broker co-owns a mortgage company and refers a client there, the client must receive written notice of the ownership interest and be informed that the broker may financially benefit from their decision. The timing of disclosure is critical. The law requires that all present or prospective interests be disclosed prior to or at the time of contract formation, never afterward. This ensures that no party enters into a transaction without full awareness of the licensee's interests. Disclosing only after acceptance would violate the licensee's fiduciary duty of loyalty and honesty. Furthermore, ARS Section 32-2153 AA5 allows the commissioner to take disciplinary action if a licensee fails to disclose ownership or personal interest in property being sold, purchased, or leased. The ADRI has routinely suspended or revoked licenses for concealment of ownership, as seen in administrative cases where agents bought properties through family members or LLCs without proper disclosure. The intent of the law is not to prevent licensees from investing or participating in transactions, but to ensure that all parties involved are fully informed and treated fairly. In addition, R4-28-1101A reiterates the duty to deal fairly with all parties, whether they are clients or customers. This means that even if no fiduciary relationship exists, a licensee must still disclose any material facts, including ownership or potential financial interests that could influence another party's decisions. The ethical foundation of these laws is built on the idea that honesty and disclosure are not situational. They are universal expectations of every Arizona real estate professional. For real estate brokers, title companies, lenders, and other settlement service providers, Section 1024.15 is critical because it governs how affiliated business arrangements must be structured and disclosed to avoid triggering illegal referral fee or kickback liability under RESPA. It essentially allows a legal path for FBAs if the strict criteria are met. Otherwise, the arrangement may be deemed a prohibited referral fee or steering arrangement under Section 1024.14, the Anti-Kickback Unearned Fee Rule, and Section 2006-107 of RESPA Review Summary. Licensees must disclose all present or prospective interests, ownerships, or financial conflicts in writing and before entering into any transaction. This includes acting as a principal, representing family members, owning partial interests, or expecting future profits. Disclosure must be clear, timely, and documented in the broker's transaction file for at least 5 years as required by ARS Section 32-2151.01. These requirements exist to protect consumers and maintain public confidence in the Arizona real estate industry. Transparency not only fulfills legal obligations, but reinforces the ethical foundation of trust between clients, customers, and real estate professionals. Discussion. Why must licensees disclose ownership or financial interests before entering into a transaction? Answer. Because under ARS Section 32-2153A3 and R4-28-1101, full written disclosure prevents concealment, ensures fairness, and maintains the client's right to make an informed decision. What happens if a licensee purchases property for themselves without disclosure? Answer. It constitutes misrepresentation and may result in disciplinary action such as suspension or revocation of their license under ARS of 32-2153A5. Why must prospective interests, not just current ones, be disclosed? Answer. Because anticipated benefits, such as future ownership or partnership profits, can influence the licensee's judgment and must be revealed to avoid constructive fraud as established in Hoffman-Frake-Greenberg. The seller could have disclosed the original appraisal if John Olson had gotten permission from Greenberg, Campbell, and Associates to do so. Closing remarks. A real estate professional's credibility is defined by transparency, whether buying, selling, or referring. A licensee must never leave room for doubt about their personal or financial interests. Arizona's laws require full and timely disclosure. Because honesty is not merely good ethics, it is the cornerstone of lawful practice. By proactively identifying and disclosing present or prospective interests, licensees protect themselves, their clients, and the integrity of the real estate profession. The more open the communication, the stronger the trust. And trust remains the currency of every successful real estate transaction. When in doubt, disclose.